Hi class, for this recording, we shall be discussing about Article 4 of the Revised Penal Code. We have previously discussed Article 4 during our face-to-face classes. However, I find it important to highlight this provision because it is intimately related or connected with Article 48 on complex crimes and Article 49. So before we go there, we shall master Article 4. Okay. But before we start with our Article 4, it is important to have a quick recall of our Article 3 on felonies. During our discussion sa Article 3, mo ni ato ang mga nahisgutan last time. So, Article 3 talks about what are felonies because Article 3 is a definition of felonies. What are felonies? Mo ni siya ang naa sa Article 3. Acts and omissions punishable by law or the revised penal code are felonies or delitos. Felonies are committed not only by means of deceit or dolo but also by means of fault or culpa. There is deceit when the act is performed with deliberate intent. We already learned this. There is fault with the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. So during our previous discussions, naghisgot tayo sa taog difference between felonies versus offense versus misdemeanors versus crimes. Hisgutan na nato siya. You already know that. We also discussed about the classification of felonies. Naghimo tag code nga MSG CN. So, ang felonies gi-classify siya according to the manner of commission, according to the stages of their execution, as to their gravity. Hibaw ta ana. Nakahibaw ta nga naapoy classification as to count and as to nature. We also learned about the purpose of classifying felonies. Okay, so before we proceed sa atong Article 4, we shall have a quick recall of these discussions. Sa atong previous discussion class, gitabulate nato kung ang classification of felonies. So as to manner of their commission, we have intentional and culpable felonies. Unsa ang article? Asa ni makitaan? Naan ni siya sa Article 3. Kaniniya. So, ang stages of their execution, nakahibaw ta nga nay attempted felonies, nay frustrated, nay consummated. Asa man na siya makitaan sa Article 6. Ato na po ni siyang na-discuss. As to their gravity, we have grave felonies, less grave felonies, and light felonies. Unsa mga relevant articles nga we have to connect to this topic? Mao ni siya, Article 9, we have Article 25, Article 7 sa Revised Penal Code. We discussed this, kinumdum mo sa ato ang gihimo dito sa blackboard, mao ni siya. So as to count, we have compound crime, complex crime, composite crimes. We connect that to Article 48 of the Revised Penal Code. Mao ni akong na-mention ganina. So as to their nature, we have mala in se and mala prohibita. You already learned that, kaya ito po na siyang na-discuss previously. We also learned class about the purpose or purposes of classifying felonies. And these are as follows. Number 1, to bring about a proportional penalty and equitable punishment. Number 2, the penalties are graduated according to their degree of severity. Kainom mo class ato ang gidrawing sa blackboard nga kung ang person gali ni commit sa felony, dili na siya, or there are several persons who committed a felony, lahi-lahi po na siya o mga penalties class according to their participation. Ato pong nahibawan last time nga kung lahi-lahi ang gravity sa gi-commit nga felony, lahi-lahi po na siya o penalty. Okay, so mo na siya nga importante nga ato yung gina-classify ang felony, whether it is attempted felony or a frustrated felony or a consummated felony. Okay? We also discussed about the elements of criminal liability under Article 3. So, ang first element is that there must be an act or omission, actus reus or physical act. So, in relation to that, we need to discuss about act or omission. Okay, unsa man ang act? Ang act class is any kind of body movement which tends to produce some effect in the external world. It includes possession. Omission class is the failure to perform a positive duty which one is bound to do under the law. What do you mean by positive duty? Niradapita. Ang positive duty class, it means that there must be a law requiring the doing or performing of an act Okay? So, kinahanglan ko nun ay balaod nga nag-require sa pag-perform sa usa ka butang. Okay? So, what are the examples? You might be asking, unsa man ang mga examples pod ma'am nga kanang gipunish siya or naibalaod nga mo punish by not doing anything. Okay? Or omission siya. So these are the examples of crimes by omission. So punishable omissions in the revised penal code. Number 1, Article 116, misprision of treason. Unsa man ang misprision of treason? Kana bitaw nakahibaw ka class nga naay treasonous design bitaw, naay plano nga mo himo sa naay conspiracy to commit treason or naadjud treason nga gi-actually performed. Unya ikaw nakahibalo ka pero wala ka mo sumbong sa hingtungdan or wala ka misumbong sa authorities. Mao na siya misprision of treason. So can you see the example? There's an omission on the part of the person to tell the authorities nga naay nag-conspire to commit treason or naay mo commit na of treasonous act. Okay? Number 2, Article 137 of your Book 2, Revised Penal Code, disloyalty of public officers or employees. Number 3, Article 208, negligence and tolerance in prosecution of offenses. 223, conniving with or consenting to evasion. Article 275, abandonment of person in danger and abandonment of one's own victim. Article 276, abandoning a minor. So, you shall learn these crimes class when we tackle or when we go to book 2. Pero for now, all you have to remember is that ang criminal liability, ma-incur na siya kung ning-act ka in violation of a law or ning-omit ka sa pag-perform sa usa ka law which pag-perform sa usa ka butang which the law requires you to do or perform. Okay, so you have to remember that because during the exams I will be asking ang kuan ra ba ang kaning crime makumit lang ba na siya by action? True or false? Of course, you know the answer to that. The second element class is that the act or omission that I discussed a while ago must be punishable by the revised penal code. So there is a law requiring the performance of act, and if there is no positive duty, there is no liability. So moro dyan na siya explanation ana niya class. Third element of criminal liability class under Article 3 of the revised penal code is that the act is performed or omission incurred by means of dolo or culpa. So here, class, we will learn that there are intentional felonies na apoy gitawag og culpable felonies. So we go first to dolo. What do you mean by dolo? Dolo, class, it refers to deliberate intent or also known as criminal intent, must be coupled with freedom of action and intelligence on the part of the offender as to the act done by him. Okay, so here, maghiskutay ta og intentional felonies. What are the requisites of intentional felonies? Number 1, natay code class ha, FIC. Freedom, intelligence, and criminal intent. FIC ha, criminal intent ang last. Kung maghisgot tayo nagalitag culpable felonies class, mapulihan ng C ug N. Okay? Instead of FIC, mahimo siyang FIN. Unsa man pod ang mapuli ana? You will learn later on ang criminal intent will be replaced by negligence, lack of skill, lack of foresight. Okay? So, ato na siyang ma-discuss later on. So, let's go first sa intentional felonies and the requirements. Number 1, freedom. Freedom means voluntariness on the part of the person who commits the act or omission, A or O. Okay, so what is the effect man class of lack of freedom? If in case gali na wala siya kagawasan nga mubuhat sa usa ka butang. Unsa man ang effect ana? The person is exempt from criminal liability. You connect that to your Article 12 of the revised penal code. Unsa may example ana? Presence of irresistible force. Usa na siya sa mga circumstances under Article 12. You know that kay ato nang gi-perform sa atong PLA. Presence of irresistible force or uncontrollable fear. Unsa may example ana, classic example. Kung example kita ikaw Pedro, gihadlok ka nga kung dili gali nimo patyon kanini ang ako ang gipapatay nimo, akong patyon ang imuhang pamilya, o di ba? Kung ingon ana gali nga sitwasyon, do you have the freedom nga mobalibad sa iyang gipabuhat? Wala. So kung ma-establish na by evidence nga naay presence of irresistible force or uncontrollable fear, mawala ang freedom sa requisites, di ba? So mawala siya, ma-erase siya sa requisites sa intentional felonies, which is FIC. So nawala ang F. So unsa man ang effect kung nawala ang freedom? The person will be exempt from criminal liability under Article 12. Okay? Second is intelligence. Intelligence means capacity to know and understand the consequence of one's act. So, unsa man day sad ang effect kung walay intelligence or effect of lack of intelligence. Ang effect ana class is the same as the effect of kana kung walay freedom. So, kung walay intelligence class, under Article 12, the offender will also be exempt from criminal liability. So, unsa may mga example ana? The offender is an imbecile, insane, or under 15 years old. So, kung buang gali ka class unya, kung usa ka person kita hay buang, unya kauman paning nakakommit kita siya og krimen, ma-establish gali na siya by evidence class nga sa pag-perform niya during the performance of the criminal act, ma-establish gali nga buang siya ana nga time, wala siya sa lucid interval, meaning buang jud siya, wala siya intelligence anang panahona. So kung walay intelligence, nawala ang usa sa elements sa intentional felonies. So unsa man ang impact ana kung ni-perform ka sa usa ka butang nga wala kay intelligence, meaning wala ka kahibaw unsay consequence sa imuhang gibuhat. Ang effect ana class is you will be exempt from criminal liability. Unsa may another example ana, kung minor ka, 15 years of age. You will learn later on class nga natay gitawag og kanang minimum age of criminal liability, criminal responsibility. So kung 15 years of age gali ka class, unya ning perform ka sa usa ka butang nga wala ka kasabot sa imuhang sa consequence sa imong gibuhat. Tungod sa imuhang pangidaron, you will be exempt from criminal liability. So this is another discussion class nga ato ang i-insert later on sa katutuang liability of CICL or children in conflict with the law. So maghisgot tayo ani later on para dili ma-complicate ang ato nga discussion. Ang last nga requisite class sa intentional felonies to complete the kanang FIC class is criminal intent. C, criminal intent. So, what is meant by this? It refers to general criminal intent. You will learn later on nga naay gitawag og specific criminal intent. Ang kaning pasabot ani ni ang requisites class sa intentional felonies, kaning criminal intent, ang atong gihisgutan ani is ang katong general criminal intent. So, unsa man ang criminal intent? It means the purpose to use a particular means to effect a result. So, it is purely a mental state, and intent to commit an act with malice is presumed. So, kaning general criminal intent class is presumed, but only if the act committed is unlawful. So, unsa may pasabot ani class? Meaning, kung nanagali ning resulta nga unlawful act, nga nahitabo. For example, namatay. Kay gipatay siya, intentionally gipatay siya. Kung nagali death nga ning result sa intentional nga killing, there is an unlawful act nga nahitabo. So kung nagali ng unlawful act, automatically presumed na jud na siya na ay general criminal intent. Okay? Kay nagoy nahitabo nga act, criminal act. So therefore, na jud presumption sa balaod nga naay criminal intent ang person nga ning perform sa mao nga salaod. Okay? Such presumption class arises from the proof of commission of an unlawful act. Okay? Mo na siya akong gisgutan ganina. Kung nagali nakitaan or proof nga unlawful ang na-commit ang unlawful act, automatic na siya nga nay presumption nga ang katong ni perform ani nga mao nga act naa jud siya criminal intent. Okay, so we will discuss later on unsa man po ng specific criminal intent. Do not do not confuse yourself sa katutoa bitang proof beyond reasonable doubt and general criminal intent. Ang proof beyond reasonable doubt class meaning katotoang usa ka ang intent nga gi-require sa balaod nga na dapat jud hatagan og pruweba beyond reasonable doubt is katong specific criminal intent. Kaning general criminal intent class under intentional felonies class presumed na siya if there is proof of commission of an unlawful act. Ang criminal intent class under the requisites of intentional felonies class is also called mens rea. So may pasabot ani, a guilty mind, a guilty or wrongful purpose or criminal intent. Okay? So again, I mentioned ganina nga this refers to general criminal intent. So ang kaning general criminal intent class, listen to this because this will be discussed in a separate discussion about mistake of fact. Kaning general criminal intent class can be destroyed by an honest mistake of fact. Okay? An honest mistake of fact destroys the presumption of criminal intent which arises from the commission of a felonious act. Kaning mistake of fact class will be discussed in a separate slide or a separate recording para walay confusion. Di ba naghisgotay man ko ganina class ko sa specific criminal intent? Ang specific criminal intent class is not presumed. Okay? Unsa man ang specific criminal intent? You have to contradistinguish that sa general criminal intent as element of intentional felonies. Ang specific criminal intent class is the intention to commit a definite act. It is an element of the crime. It is not presumed. Therefore, the burden is upon the prosecution to establish its existence. Mo na ni ang akong giingon kanina class nga ang specific criminal intent must be proved beyond reasonable doubt because it is one of the elements of the crime. Okay? So, unsa may example ani? Kani, frustrated homicide. Unsa man ang specific intent sa frustrated homicide? Specific intent to kill. It is not presumed. It must be proven. Otherwise, merely physical injuries na siya. Di ba frustrated class na may namatay? Kung frustrated, wala. So, kung walay namatay, naadjud na siya gamay confusion unsaon pag kuaniya, unsaon pag treat ani ni nga mao nga act. Is it physical injuries lang or frustrated homicide? So, tungod kay naay confusion siya, mao na nga naay ang element sa kaning frustrated homicide which is intent to kill maoy mo separate niya or maoy mo kuha niya from doubt nga dili siya physical injuries lang, frustrated homicide siya. Ngano man ang physical injuries na by criminal intent or intent to kill? Wala, di ba? Kaya ang imong intent sa physical injuries is imuhara siyang bunugon. Walay intent to kill. Pero if ma-establish gali nga naka-intent to kill, mahimo siya, ma-convert siya into frustrated homicide. Again, nga namang importante man to prove beyond reasonable doubt the intent to kill. Because frustrated homicide class, walay namatay ana. So, mao na siya, na-thin line ba between frustrated homicide and physical injuries. And what separates frustrated homicide from physical injuries is the specific intent to kill. Okay, nasabtan class ha. The same goes sa frustrated murder class. Nandun siya intent to kill. Mo na siya mga example sa specific criminal intent. Another example, kanini robbery. There must be, or theft, there must be intent to gain. or kaning Article 342, forcible abduction, there is intent of lewd design. Unsa man ang lewd design class? Ngano makitay kinahanglan pa man jud nga i-lewd design pang nalalaman? Lewd design class is lust or kaulag. Hibaw mo anak. Anad kay mo anak, mga laki anak. Okay? So, lewd design class, mo ni siya ang common nga elements sa crimes against chastity. Usaan na ang example is forcible abduction. You will learn that sa inyong nga book 2. Di ba ganina class naghisgotay man ta kung unsa man ang effect sa kaning lack of freedom or na-absent ang first elements sa intentional felonies. Unsa man ang effect ana? Ang effect is mahimo siyang exempt sa criminal liability under Article 12 because wala siya freedom. Unsa man pud ang effect kung naay kung wala ang intelligence, ang second element sa intentional felony. Kung naay lack of intelligence class, against the same nga effect under Article 12, exempt siya sa criminal liability. Okay? So unsa may mahitabo kung wala po'y criminal intent? The effect or the absence of any requisite class, or this specifically kaning criminal intent, there is no dolo. So meaning, walay criminal intent. If there is no dolo, there could be no intentional felony. So the next question that would arise ani class, kung walay dolo, unya walay intentional felony, nagpasabot ba nga walay krimen? What do you think? So going back to the question, is there liability even in the absence of criminal intent? Ako mong gipangutana ganina, unsa may answer ani? The answer class is yes. Of course, nagihapoy criminal liability ngano man. Ngano dolo ra di ay tanan ang kuan kaning ang felony. Intentional felony ra di ay na mapoy gitawag og felonies committed by culpa or culpable felonies. Naapoy offenses nga mala prohibita katong violation sa special penal laws. Do you remember sa atong previous discussion nga ang offenses or katong violation of special penal laws nga gitawag natong mala prohibita walay intent, kuan siya, wala dili relevant ang criminal intent. For as long as you violated the law, walay purpose or walay gamit ang imuhang pag-ingon nga wala ba yun anak ko to you kay wala jud koy criminal intent to commit that. Can you do that? Can you use that as defense nga wala kay criminal intent? No, because ang special penal laws class wala mo matter kung naa kay intent, criminal intent to perform the act. As long as you violated the law, automatic ka nga mahimong punishable. Ang lack of criminal intent is not a defense. So going back to the question, naabay kuan criminal liability kung walay criminal intent? Of course, because there are what we call as felonies committed by culpa or culpable felonies na apoy gitawag og offenses mala prohibita. So here, ning proceed na ta sa culpa. Di ba ganina dolo ta? So karon ari na po ta sa culpa. Kay again, dili lang dolo ang felonies. Napoy gitawag og culpable felonies. So unsa may pasabot og culpa class? Act or omission is not malicious. Mo na siya pasabot. Walay malice. Okay? So ang requisite sa culpable felonies class, I mentioned that a while ago, gi-replace lang jud ang C og N. Okay? So, maintain na gihapon ning freedom intelligence. Kuan ni sila, dapat naa jud ni sila kanunay, whether dolo or culpa. Naglahi lang sila sa katapusan nga element. So, unsa man ang last elements sa culpable felonies: negligence, reckless imprudence, lack of foresight, or lack of skill. Ato na siyang nabasa sa atong Article 3 ganina. So, ang injury caused class under culpable felonies is incident or result siya of another act performed without malice. So meaning na usa ka butang nga gibuhat without criminal intent, without malice, nakadanghag lang jud siya, mao nang naka-cause siya og injury. Although there is no intentional felony, there could be culpable felony. Ako na siyang na-mention kanina. The element of criminal intent is replaced by NIFS or negligence, imprudence, lack of foresight, or lack of skill. So class, we are done with our quick recall sa Article 3. So now we go to the discussion sa ato ang Article 4. Sa Article 4 class, mo ni siya ang mga topics nga atong hisgutan: proximate cause and impossible crimes. So under proximate cause class, we will know about error in personae, or mistake in identity, aberratio ictus or mistake in the blow, and praeter intentionem, or which means injurious result is greater than that intended. So, kaning Article 4 class, ningingon ni siya nga ang criminal liability kuno shall be incurred by the following. Number 1, by any person committing a felony, although the wrongful act done be different from that which he intended. Meaning class, kung you have to take note class nga committing a felony or delito, this refers to intentional felonies class or dolo. Wala ta maghisgutay ani og kulpa class ha. Meaning, ang usa ka person ning perform siya og intentional felony pero ang resulting act class is different from that which he intended. So bisan pa og lahi ang resulta sa iyahang iyahang gibuhat, mahimo gihapon siyang criminal liable anang mao nga action. Okay? So paragraph 1 of Article 4 class refers to proximate cause. Ang paragraph 2 class nag-refer ni siya og impossible crime. So unsa man ang ikaduha nga group of persons nga mahimong criminally liable. Number 2, ma-incur ang criminal liability by any person performing an act which would be an offense against persons or property were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. So take note, aning impossible crimes class. Mahimo lang siyang punishable bisan pag impossible crime siya, meaning kung layman pa nga term, meaning wala jud siya ma-perform ang krimen. Impossible crime siya. Pero gihimo gihapon siyang punishable under Article 4 if the offense is against persons or property. So you will learn that in your book 2 sa Revised Penal Code nga naay crimes against persons, napoy crimes against property. So kung maghisgotay gali tag impossible crime class, wa na siya maghisgotay og crimes committed by public officials or crimes against chastity or crimes against security, wala ta maghisgotay ana, ha? Ang ato ang gihisgutan kung impossible crime para mahimo siyang punishable bisan pag in truth and in fact wala jay krimen nga nahitabo tungod kay impossible crime lagi siya. Gipunish lang siya kung ang kani nga mao nga act giperform siya against persons or property. Although wala jud siya actually na-accomplish ang krimen. So you will learn later on unsa man ang rason sa balaod nganong i-punish mo pud siyang impossible crime man siya. Okay? So class, di ba ga-mention ko ganina nga ang paragraph 1 nag-refer sa proximate cause, ang paragraph 2 nag-refer sa impossible crime. So, ang impossible crime class under Article 59 of the Revised Penal Code is punishable by arresto mayor or a fine ranging from 200 to 500 pesos. Okay, Article 59, ang article sa balaod sa Revised Penal Code nga naghatag og penalty sa impossible crime. Again, nganong aresto mayor man siya tungod kay wala lagi nahitabo ang krimen kay impossible man siya na crime. Pero tungod kay crime against person siya and property, gihimo siyang punishable sa balaod to deter or to discourage sa mga tao to even think of performing the act. Okay? So let's go first to proximate cause. Sa paragraph 1. Ang criminal liability shall be incurred by any person committing a felony, delito, although the wrongful act done be different from that which he intended. So, kanini ang mga enumeration diri class, wrongful act siya nga nahitabo, pero different siya sa ihang gi-intend. Okay? Unsa may example ani? Number 1, error in persone, meaning mistake in identity. Lahi. Ang unsa man ang iyang intention? Ang iyang intention kay iyang patyon si Maria. Unyag ending di ay dili dayto si Maria ang namatay. Si kuan dayto si Agatha. Kay si Agatha murag porma ni Maria na iyang na kuan ba iyang nasaypan nga kay mura mang si Maria si Agatha. So si Agatha ang namatay. So unsa man ang iyang intention, di ba? Iyang intention kay si Maria iyang patyon, pero kinsa man ang namatay? Si Agatha. Mo na siya mistake in identity. Ang wrongful act done or ang wrongful act nga nahitabo, ang kamatayon ni Agatha. Pero bisan pag different siya sa iyang gi-intend, unsa man ang iyang intention nga si Maria ang namatay, the person who performed the act would still be criminally liable. Okay? Another example, aberratio ictus. Aberratio ictus class is mistake in the blow. Example na gihapon ni siya, ang wrongful act done nga different from that which he intended. So, sa may example ani, ang example, ako kitay pusilon si kana Mr. A. Unya si Mr. A, mo jud siya akong gi-intend nga pusilon pag kablit na ko sa pistola, ning hupo si Mr. A, ang ending si Mr. B ang naigo, siya ang namatay. Tungod ba kay si Mr. B ang namatay, dili siya ang intended victim nako, maka-excuse ko from criminal liability? Of course not. Because under Article 4, Paragraph 1, under proximate cause, bisan pa og lahi ang ning resulta nga wrongful act done, lahi siya sa akong gi-intend, tungod kay in the first place, ning himo ko og felony, I would still be criminally liable for that. Okay? Third, praeter intentionem. Unsa may praeter intentionem class? Injurious result is greater than that intended. So, unsa man ang akong intention kitay? For example, ang akong intention kay ako dito siyang sagpaon, si A. Unya, pag sagpa pa nako, nito libagbag bita na si A, nahapak iyang o dito sa bato, namatay siya. Unsa man akong intention? My intention is just to slap A. Pero unsa man ang wrongful act done or wrongful act nga ning result? Ang ning result is namatay si A. Pero mao ba na akong intention? Dili. Bisan pa og dili na mao ang akong intention class, I would still be criminally liable for the wrongful act done or ang ning result. Okay? So, unsa man ang rationale day class aning proximate cause? Ang rationale aning proximate cause class is el que es causa de la causa es causa del mal causado. Inganaon jud pagbasa ninyo class ha kung recitation ta. Okay, unsa may pasabot ani class? He who is the cause of the cause is the cause of the evil cause. So, diba, simple ra kayong balaod, complicated siya sama sa inyong mga relasyon. Okay, so when a person commits a felony with malice, di ba, niisgotay ko ninyo ganina nga kanini ang proximate cause refers only to intentional felonies or dolo. So when a person commits a felony with malice, he intends the consequences of his felonious act. Okay, so dili jud siya ka-excuse bisan pag different ang ning resulta sa iyang gi-intend, because in the first place ning himo siya og krimen or felony with malice, mahimo jud siyang criminally liable sa resulting act bisan pag different siya sa iyang gi-intend. Unsa man day ang definition sa proximate cause class? Proximate cause class is defined, you have to memorize this ha, that cause which in a natural and continuous sequence and broken by any efficient intervening cause. Remember this class, efficient intervening cause produces the injury without which the result would not have occurred. Okay? So, unsa man ang requisites sa proximate cause for the person to be criminally liable? Number 1, intentional felony has been committed. Ako na dyan siyang gibalik-balik kung emphasize sa ninyo class nga proximate cause does not refer to culpable felonies. So, unsa man ang atong himayoning first requisite, intentional felony has been committed. The felony class by means of dolo or with malice. Mo ni pasabot. Unsa may reason ana? You have to remember your Article 4, Paragraph 1. Di ba? Nakita na to. Ang wrongful act done be different from that which he intended. Which he intended. Unsa may pasabot og intended? Iyang gituyo. Therefore, intentional. Intentional felony siya. Okay? Act should not be punished by SPL or Special Penal Law. Dili ka maghisgotay class o proximate cause kung ang in the first place ang balaod nga gi-violate is Special Penal Law. Ngano man, specific kaayo ang paragraph 4 o Article 4, Paragraph 1 class nga by any person committing a felony. Ang felony class, unsa may definition ana, di ba? Violation of the revised penal code. Therefore, dili siya pwede kung violation of special penal law. Okay? So, it must refer to a felony, specifically intentional felony. Okay? And it must not be covered by any of the justifying circumstances. Meaning, walay self-defense, walay defense against strangers or defense against relatives. So, kaniniya sila nga mga circumstances class, dapat wala na sila. Kay kung present gali ang justifying circumstances class, wala ta maghisgot ay proximate cause. Uy, mo stop there ang criminal liability. Nga naman, na-justify man ang iyang act. Okay? Second requisite class, the wrong done to the aggrieved party be the direct, natural, and logical consequence of the felony committed by the offender. Meaning, kung unsa ang injury or wrong done, meaning resulting unlawful act to the aggrieved party or sa biktima, mao na siya ang direct or natural and logical consequence sa felony. Meaning, ang nag-trigger atong tanan is ang katong felonious act committed by the offender. Mao na siya ang second requisite. Paragraph 1 of Article 4 class, which talks about proximate cause, lays down this general rule. Unsa man ang general rule under Paragraph 1 on proximate cause? The general rule is that the offender is criminally liable for all the natural and logical consequences of his felonious act, although not intended, if the felonious act is the proximate cause of the resulting harm. Meaning, ang kadtong iyahang gibuhat nga intentional felony is the trigger. Siya jud ang nagkuan ba? Ang operative act or nag-trigger mo ning resulta ang kaning unlawful act or wrongful act to the aggrieved party. Therefore, the person is still criminally liable although the wrongful act done or the resulting act done be different from that which he intended in the following cases. Ako na ning na-mention, error in persone, aberratio ictus, praeter intentione. What is error in persone? Mo ni ang number 1. Error in persone class is injuring one person mistaken for another. Diba? Akong gi-mention ganina, ang imuhang intended victim is Maria, pero ang resulting victim is si Agata. So, bisan pa, wala ni mo gi-intend nga si Agata unta imo patyon, pero tungod kay ang imuhang trigger ang imuha jud nga initial act nga imong gibuhat is felonious or intentional siya nga felony, you will still be liable for the death of Agata, although Agata is not your intended victim. Mao ni siya ang error in persone. So, unsa man ang effect? You have to connect that. Again, class, the magic of connection. You have to connect this topic to Article 49 of the Revised Penal Code. Unsa man ang giingon sa Article 49? Si Article 49 niingon nga ang penalty for the lesser crime and its maximum. Ang ato nga impose nga penalty sa person. So unsa may example class? Balik ta ni Maria o ni Agata. Di ba si Agata ang imuhang si Maria ang imuhang intended jud nga victim? Unya si Agata ang actual or ang resulting victim. So, unsa man ang duha ka krimen nga imuhang gi-commit? Ang first nimong gi-commit nga krimen is against Maria, your intended victim. Ibutang na to attempted siya. Attempted siya nga attempted homicide kintahay. Unya naay consummated homicide as to Agata, your resulting victim. So, according to Article 49 sa error in personae class, ang i-impose nga penalty against the offender is the lower penalty or the less penalty for the lesser crime in its maximum. So kung ibutang ta ang imuhang penalty sa asa man ang lesser penalty ana class, kadto ang consummated nga kaning felony as to Agatha or ang katong attempted lang as to Maria. Of course, ang katong attempted paingon ni Maria. So ang katong felony, ang penalty nga impose unta sa attempted nga crime will be imposed in its maximum. Ang second type nato class under proximate cause is aberratio ictus or mistake in the blow. Ang kalahian sa aberratio ictus class o katong error in personae class is ang error in personae, first error in personae, wala jud ka makaila, wala jud ka makaalingat or wala jud ka makabantay nga ang person nga imong gi-attack is dili di ay tumao ang imuha dyan nga gituuhan. So ang imong intended nga victim di ba kay si Maria, unya ang imuha nga actual victim is si Agata. Pero during the performance of the act, nagtuo jud ka nga si Agata is si Maria. Ang aberratio ictus class, kahibaw ka nga imuhang intended victim is si A or si Maria. Pero tungod kay sa lack of precision kintahay, wala ka dili jud kahanas nga mopusil, ang intended victim nimo nga si A or si B kintahay ani nga example. Kahibaw ka mao jud intended victim pero ning likay kintay siya or accident kuan kintay sa during sa imuhang pagpusil kay ning kuob kintay siya. So ang naigo nga victim is si C. So diri sa aberratio ictus class kahibaw jud ka in the first place nga mao jud ni ang imong intended victim, just that due to lack of precision or due to circumstances outside of your control, ang naigo, sadyang minalas lang talaga ang resulting victim. Okay? So, ang aberratio ictus pod class, differs siya sa error in personae sa penalty. Sa error in personae class, di ba ang giingon ganina is, according to Article 49, is that ang penalty for the lesser crime shall be imposed in its maximum. Diba? Maximum period. So, ganina naghisgotay ta nga duha ka crimes ang iyang na-commit. Number 1, as to against Maria nga attempted kintahay siya nga murder. Unya, ang ikaduha is against kaning Agatha nga consummated siya nga murder. So, as between attempted murder and consummated murder, asa man ang lesser crime? Of course, ang attempted murder. So, ingon si Article 49 sa error in personae, ang penalty for the lesser crime shall be imposed in its maximum. So, unsa man ang penalty sa attempted murder? That's 2 degrees lower siya sa consummated murder. So, ang consummated murder class, we know that it is reclusion perpetua. Mao na siya ang according to the law. Ang murder is punishable by reclusion perpetua. Unsa man ang 2 degrees lower ana? Nganong 2 degrees lower man? Tungod kay frustrated attempted. Lower man jud ang attempted by 2 degrees. So, unsa man ang 2 degrees lower ana? Mao na siya ang prison mayor. So as between attempted murder nga prison mayor versus consummated murder nga kuan kaning reclusion perpetua, asa man ang lower? Ang prison mayor, which is lower by 2 degrees. Kanang prison mayor class, i-impose na siya in its maximum. Mao na siya ang dito sa error in persone. Pero kung aberratio ictus class, it's a different story. Ang aberratio ictus is ang applicable nga article ani or ang connected nga article ani is ang Article 48. Unsa man ang giingon sa Article 48? It refers to complex crimes. Unsa man ang punish sa offender? According to Article 48 class, ang penalty for the greater crime or the higher crime will be imposed in its maximum. Unsa man di ay ang meaning ani niyang aberratio ictus. Mura rin siya aning drawing class. Ako kintahay ni, akong pusilon si B, unya ang namatay si C. Tungod kay si B, during sa time akong pagpusil, naa siya gipunit nga kwarta. Kahibaw ko nga ang ako adjud nga intended victim is si B, just that tungod sa lack of precision nako, ang naigo sadyang minalas lang talaga si C. So the offender intending to do injury to one person actually inflicts it to another. Mo ni gitawag mistake in the blow. Di ba naghisgutay ko ninyo ganina about complex crime? So sa aberratio ictus class versus error in persone ha, ang aberratio ictus class Article 48 ang mo-apply. Ang error in persone Article 49. So sa error in persone, ang giingon ang penalty for the lesser crime will be imposed in its maximum. Pero sa aberratio ictus class, Article 48 ang mo-apply, which provides nga ang penalty for graver offense will be imposed in its maximum period. So ani ni ang setup class. Unsa man ang mga crimes nga na-commit? Usa ra ba? Of course not. Duha. As to B, na ako'y attempted. A, mo ni siya, attempted siya nga murder or attempted homicide ba? Pero tungod kay si C, namatay man siya, consummated siya nga murder or homicide. Diba? Kay na may death nga ning result. Unsa man ang giingon sa Revised Penal Code? According to Article 48, when a single act constitutes two or more grave or less grave. Grave, kanini ang consummated. Less grave, ang kanini ang attempted. Or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed and the same to be applied in its maximum period. So, unsa man ang i-apply sa person nganing commit ang penalty for consummated nga felony and it will be imposed in the maximum. So, ang duha ba ka penalty ang i-impose ang kanini ang sa attempted o sa consummated? No. Nga naman, single act naman ang iyang gibuhat. Meaning, single crime ang iyang gi-commit. Just that nasaypan lang jud og ego. Therefore, usa ra sad siya ka penalty ang i-impose anini ang offender. Unsa man ang i-impose? Ang katong penalty for the graver offense and it will be applied in its maximum period. Since your aberratio ictus class is related to Article 48, so we will discuss na lang siguro unsa ang rules under Article 48 on complex crimes. So again class, sa Article 48 class, bisan pa og daghang krimen or two crimes are committed or two felonies are committed, one penalty ra ang i-impose ana. Nga naman, single act ra mangud siya class. Okay? So, one penalty lang ang impose, pero ang i-impose is ang katong sa graver offense and it will be applied in its maximum. So, there are two types of complex crimes. Number one, one single act constitutes one or more grave or less grave felonies. Ang combination anini ang first type sa complex crime class is grave plus grave or grave plus less grave na felonies or less grave plus less grave. One intention ra, one single act ra siya. But you cannot complex light felonies. Nga naman, ingon ba sa Article 48 nga when a crime, when a person commits grave or light felonies, wala ba siya niingon? Niingon ra siya nga grave or less grave. So, ang combination aning Article 48 nga complex crime under paragraph 1 is grave plus less grave, or grave plus less grave. Less grave and less grave. Okay? So, dili ka maka-complex kung light felony. Unsa may effect ana? Kung ang imuhang action na kay single act nga na-commit, unya ang intended act kintahin nimo na belong siya sa light felony, dili siya sa less grave felony, mahimo kang liable for both. Di ba? Ang akong giingon ganina kung Article 48 sa complex crime, one single act, therefore one penalty. Unya ang i-penalize lang nimo, impose lang sa imuha is ang graver offense in its maximum. Pero kung light felony gali ang ning combine sa grave felony, you will be punished sa both. So you will serve sa light felony nga penalty, you will also serve sa grave felony. So dili na siya complex crime. Dili na siya one penalty only. Okay, nasabtan. Number 2, ang second type sa complex crime. An offense is a necessary means for committing the other. The first offense must be consummated, and if common elements are absorbed, you cannot complex. Unsa may mga example na ng common elements? Ibutang nato aring crime of rebellion. Kaning rebellion class. Unya naa kintahay elements sa intent to kill, which is homicide. According to the law class or according to jurisprudence, kaning mga Supreme Court decisions, kaning intent to kill is absorbed ni siya sa crime of rebellion. Ngano, nabaday rebellion nga walay intention nga mopatay. Naaman dyan na siya. So, di ta maghisgutay og complex crime. Absorbed na siya. Meaning, nasuyop siya kay common man ang ilang element, duha nga krimen. So, wala tay gihisgutan nga one penalty sa graver offense imposed in its or applied in its maximum. So, kung dili ka maka-complex, you will be punished for both crimes. Okay? Ang third type nato class sa katutoa bitang criminally liable ang person bisan pa og ang iyahang gi-intend ang resulting act or ang felonious or ang criminal act or wrongful act done is different from that he intended is ang praeter intentionem or pasabot ana is injurious result is greater than that intended. Di ba naghisgot tayo ko ganina class nga ang ako untang intention is sagpaon ra unya ka man papagsagpa pa kay nalipong man siya, pagkalipong niya nahapak siya dito sa bato, paghapak niya sa iyang sa bato namatay siya. Ang akong intention, intended act is mosagpa ra, pero unsa man ang resulting act, namatay siya. Di ba? Pero am I not liable for the death tungod kay kuan kanang akong intention is mosagpa ra? No, because under paragraph 1 article 4 under proximate cause I would still be criminally liable for that. However, class, you connect that to your article 13 paragraph 3. Bisan pag criminally liable ko, it is considered as mitigating circumstance. Kay bao naman mag-unsay mitigating circumstance to? Mitigating circumstance mo lower siya sa penalty. Unsa man ang paragraph 3 sa article 13 that the offender had no intention to commit so grave a wrong as that committed. Meaning, bisan pa og mahimo kong liable sa death sa person, bisan pa ang akong intention is mosagpa lang, pero naalang ko mitigating circumstance. Liable ra gihapon ko. So, if A's act constitutes sufficient means to carry out the graver felony, he cannot claim praeter intentionem. Okay? So, always remember, class, I have to highlight this. Ang praeter intentionem as mitigating circumstance is not available in violations of anti-hazing law as expressly provided therein. Meaning, kung appeal gali mo aning mga kuan kaning mga sorority unya ka man pa namoy mga bunal-bunal unya pag bunal-bunal pa ang intention unta ninyo is a brotherhood naman ta o sisterhood oy ang akong i-welcome siya pero tungod sa hazing namatay man siya Can you claim praeter-intentionem nga ingon ka nga, oh your honor, wala bi adyo ko intention nga mopatay. Ang injurious result ana wala dyan na ako gi-intend. Ngano man kay ang akong intention ra is brotherhood or sisterhood. Can you say that nga mitigating circumstance na siya ang praeter-intentionem? No, because under the anti-hazing law, gi-provide dyan na siya, expressly provide nga dili ka makaklaim as mitigating circumstance. Nganong nahitabo man ni siya? Tungod atong one instance nga na I do not know kung nangatao na ba mo, pero instance magod class sa una nga, before nahimo ning anti-hazing law, naay namatay tungod sa hazing. Unya iyahang gi-claim ni as mitigating circumstance. After that, na-cut on ning learn man jud sa experience nato no. Ana man jud ta mo learn after ta masakitan. So ang kongreso ning learn siya sa experience nga di man day maayo ni praeter-intentionem kay maklaim man na siya maklaim man lang na siya sa katutuang magbunal-bunal sa mag-haze kintahay sa ilang mga sakop nga halawa biya na nako tuyo So meaning mamitigate ang iyang nga penalty. For now, tungod adto nga mao nga experience nakatunta so gigam-an siya balaod nga gi-express na jud didto nga sa hazing dili ka makaklaim sa praeter-intentionem as mitigating circumstance. Okay, so are there instances where the felony committed is not the proximate cause of the resulting injury? Naabay nga nga instances? Of course. Unsa man ang mga instances nga dili ka criminally liable bisan pag ang proximate ang felony committed is naay resulting injury unya naa kay act pod nga nabuhat pero dili ka mahimong criminally liable. So unsa man ang mga requirements? Number 1, there is an efficient intervening cause. Efficient intervening cause. What do you mean by that? Active force that intervened or nagpatunga between the felony committed and the resulting injury. Number 2, the active force is a distinct act or fact absolutely foreign from the felonious act of the accused. Meaning, separate jud siya nga act nga ni-intervene or nagpatunga sa felonious act o sa injury. So, kung maghisgot ka diri sa daplin nga naay felonious act, meaning criminal act sa person, unya, naay resulting injury diri sa kilid, naadyo na siya nagpatunga nga efficient intervening cause. Nga independent siya sa criminal act nga nag-trigger sa felonious act. Kung naay efficient intervening cause nga nagpatunga, dili siya mahimong criminally liable. Okay? Number 2, the resulting injury is due to the intentional act of the victim, meaning tinuyuan sa biktima. So, kung tinuyuan, ma-establish gali siya by evidence nga tinuyuan siya sa victim nga mo na nahitabo sa iyaha nga kuan nga injury sa iyaha, then maka-claim siya og excuse ang person. Kay ngano man naa may nagpatunga dili man connected ang katong iyahang nga felonious act og ang resulting injury. Okay? So unsa man ang test sa sufficiency? How do you know that the intervening cause is sufficient or there is an efficient intervening cause? The intervening cause must be new and independent, not under the control of the original wrongdoer, or one which by the exercise of reasonable foresight and diligence he should have anticipated and guarded against. It must break the continuity of causal connection between the causal connection between the original negligent act and the injury so that the act or omission cannot be said to have been the efficient cause of the injury. So, unsa may example ani class? Kanini siyang example class ha, ako ani siyang kaugalingon nga opinion, dili ni siya opinion sa kanang writer sa libro nga akong gihimo nga reference. So, unsa may example ani? Kaning negligence of the defendant or the defendant's negligence which preempted the effect of plaintiff's negligence. Unsa may example, classic example, nasa expressway nga insidente, namatay by road accident ang pedestrian. Nganong namatay man siya? Because of kanang ang driver na siya'y go beyond siya sa speed limit. Pero at the same time, ang pedestrian or ang person failed to heed or failed to follow the sign nga bawal tumawid dito. Bawal tumawid kay expressway go na siya. So kung imo siyang tan-awon class, unsa man ang cause? Unsa may nag-trigger sa death? Di ba ang nag-trigger class is kusugra kayo ang dagan sa katong driver. Driving beyond 60 km per hour nga limit. For example lang, for the purpose lang sa example. Mo na siya cause, mo na siya, og imo siyang una-unahon, mo trigger. Unsa ang effect? Namatay ang pedestrian or katong person nga ning latas. Pero naabay sufficient intervening cause? Yes, there is. Unsa man? Ang negligence or failure sa defendant nga mo follow sa traffic rule nga bawal tumawid dito kay expressway man to siya. So kung imo siyang analyson class, naay nagpatunga nga intervening cause, efficient siya and sufficient nga ma-erase ang criminal liability sa driver tungod kay kinsa may in his reasonable mind motabok sa expressway o kinsa man nga driver nga mag-expect or naay reasonable expectation nga naay mulatas anang ana na ang kanini ang expressway o kanini ang dalan nga expressway man siya, di ba? So pwede siya nga magamit nga excuse sa person or sa offender, pero that's a matter of evidence. You have to remember, class, nga that's a matter of evidence. This is just for the sake of example. So, kung imo siyang analyson, class, ang sufficient intervening cause nga nagpatunga sa kadtong driving beyond speed limit o sa effect nga namatay nga pedestrian, sufficient siya, new siya, and independent siya sa act or sa original act of the wrongdoer. Okay, nasabtan ninyo, class, ang sufficient intervening cause. I hope you understand it, ha? So, sa Article 4, class, nahuman na ta aning approximate cause, aning tulo ka mga items, nahuman na niya siya to discuss. So, let's go to impossible crime, which is paragraph 2 of Article 4. Unsa man ang impossible crime, class? Kung imo jud siyang analyze, ang impossible crime is wala jud siya nahitabo nga krimen. Imposible nga krimen nga mahitabo. Tungod kay na inherent impossibility of its accomplishment. Okay? So, nga naman nga i-punish man pod ang impossible crime nga kung imo siyang analyze, wala man jud crime to speak of. The purpose of the law of punishing impossible crimes is to suppress criminal propensity or criminal tendencies. Nga naman kaning mga tendency nga kanamo kuan mubuhat na kay mga criminal tendencies ba nga mubuhat o krimen against person or against property, gisuppress na siya sa balaod by imposing penalty sa impossible crimes kay aron nga dili ka maghunahon na in the first place to commit the felony. So, objectively, the offender has not committed a felony, but subjectively, he is a criminal. Nga naman, kay sa iyang huna-huna, nag-commit naman siya og krimen, pero nalay inherent impossibility nga wala jud ma-accomplish ang krimen. Pero sa iyahang kaugalingon, kriminal na siya. Okay? So, what are the requisites of impossible crime? So, number 1, that the act performed would be an offense against persons and property. Tanaw ha, specific. If I ask you during the exam, is there an impossible crime against chastity? True or false? Kung naay mo yung true, ako jud siyang padalhan o kaning libro sa book 1 sa criminal law nga kinahanglan niya memorizon. Okay? So again ha, crimes against persons or property. There is no impossible crime of kidnapping. Nga naman, it is not a crime against person or property. Kaning kidnapping. So, you have to connect that to your book 2 for you to know kung unsa ning mga crimes against persons and property. Okay, number 2 nga element. The act was done with evil intent. Number 3, that its accomplishment is inherently impossible or that the means employed is either inadequate or ineffectual. Number 4, the act performed should not constitute a violation of another provision of the revised penal code. Kay kung ang act nga imong gi-perform mo constitute pud siya og another crime, then you will not be punished by impossible crime. I-punish ka sa katong other crime nga na-commit. One of the element of impossible crime class is inherent impossibility, meaning the act intended by the offender is by its nature one of impossible accomplishment. So, unsa may pasabot aning inherent impossibility? Two types. Number 1, legal impossibility. And number 2, physical or factual impossibility. Sa legal impossibility class, the intended acts, even if completed, would not amount to a crime. So, physical or factual impossibility na extraneous circumstances or outside circumstances unknown to the actor or beyond his control prevent the consummation of the intended crime. So, again, what is the penalty for impossible crimes? Ang impossible crimes class ha, again, akong ibalik-balik dyan sa inyo ha, ang impossible crimes, wala dyan na siya krimen nga na-commit because of its inherent impossibility. Pero, gipunish siya sa balaod tungod kay gusto sa balaod i-prevent ang criminal tendencies or propensity. So, unsa man ang relevant article nga mo punish sa impossible crimes, it is Article 59. According to Article 59, ang impossible crimes, bisan pag wala siya ma-accomplish, punishable siya by arresto mayor or a fine ranging from 200 to 500 pesos. Okay, let's test what you learned about impossible crimes. So, number 1, first question, killing an already dead person. Is this an impossible crime? Kung imo siyang hunahon subjectively, criminal man jud ang person. Ngano man, nagud siya intention nga mopatay. Nahitabo lang jud nga patay na daan ang iyang patyunon. So, is this considered an impossible crime? Yes, it is an impossible crime. Ngano man, kay naay inherent impossibility or naay extraneous impossibility nga beyond siya sa control sa perpetrator. So, it is a crime against person because your intended crime is murder or homicide. It is a crime against person. Pero, tungod kay na-inherent impossibility, patay naman siya daan, so wala jud ma-accomplish or ma-consummate ang imuhang crime nga gi-intend. Pero, tungod kay wala jud siya ma-consummate, is it punishable or not? So, it is still punishable. Pero dili na siya dito sa Article 248 or 246 sa homicide or sa murder. Ari na kas Article 59 because it is considered an impossible crime. Okay? Second, nga question. Firing the house of his ex-girlfriend who is not there. Kung imo siyang hunahunahon, analyson, ang iyang intention is iyang patyon ang iyang ex-girlfriend. Pero, wala man iyang ex-girlfriend dito. Is it an impossible crime? Kung imo siyang tan-awon layman's term, yes, impossible crime siya. Kay imong intended crime is to kill your girlfriend. Pero tungod kay wala man siya dito sa ilhang balay, di wala nimo mapatay ang imong girlfriend. Pero legally speaking, impossible crime ba siya nga punishable lang by arresto mayor? Of course not. Ngano man, namanggog kay ang act manggod of firing the house constitutes another criminal offense. Dili siya which is separate sa imuhang impossible crime. So tungod kay naay separate offense or separate crime by firing the house, at the very least ang kanini ang imuhang krimen is kuani siya, ang imuhang krimen ani is unjust vexation. For example, kay gusto lang ka moguba sa property sa kanini ang person. So at the very least, naay krimen nga na-commit. So tungod kay na-commit nga krimen, dili siya impossible crime nga punishable lang under Article 59. You will be punished you will be imposed with a penalty sa katong crime nga imuhang na-commit. Okay? So, that ends our discussion sa Article 4. You have to listen to another recording after this to complete your assignment for today. Thank you so much for your time and God bless.